his sentence out of Kent County, that offense post-dated. So this offense happened prior to that, or is alleged to have happened prior to that, was my understanding. So it's the reasoning for that. Killebrew, as of right now, his earliest release date is June 9th, 2025, out of with a maximum discharge date of March 9th, 2029. I expect that earliest release date to go up by at least a little bit. But other than that, that is the understanding of the plea.
Okay. Mr. Capillo, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Josiah Capillo?
Yes.
Mr. Capillo, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, unlawful driving away of a motor vehicle?
Yes.
Do you understand that the maximum possible penalty for that offense is 5 years in prison?
Yes.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes.
Other than, as we've discussed it on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. Capillo?
Yes, it is.
If a guilty plea is accepted, there'll be no trial, giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Capillo, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
And you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application to leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you today?
No, sir.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about June 15, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of unlawful driving away of a motor vehicle?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
None other than what's been placed on the record.
Okay. And do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Capillo to plead guilty today?
No, Your Honor.
Mr. Capillo, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazier, would you like to cover the factual basis?
Yes, Your Honor. Mr. Capitello, first of all, you understand that the agreement is that your guidelines would not exceed 15 to 23, or excuse me, your sentence would not exceed 15 months to 5 years, which is the same sentence you got in Kent County. You understand that?
Yes.
However, that could result, as Ms. McClure indicated, it could result in bumping your early release date a little bit, depending on how much credit for time served you get on this file. In other words, it could, it might result in you getting out a little bit later. Do you understand that?
Yes, I do.
All right. And also we've indicated that, we've just I just kind of dropped this on her today that was your sentence range was 5 to 23 over in Kent County. Now, if it comes up considerably different than that, or for any other reason, if Miss McClure wants to withdraw the plea, she will do that, ask to do that before sentencing. Do you understand that?
Yes, I do.
Okay. In regards to this charge, it indicates that on June 21st of 2023 that you did here in Lenawee County, the state of Michigan, drive away a motor vehicle, in particular a Grand Cherokee that belonged to Cliff Buick. Is that correct?
Yes.
Well, this was where you and some guys went to Cliff, I think after hours, and you ended up stealing a Jeep. Is that correct?
Yes.
And then you drove that back to Jackson County?
Yes.
Okay. I don't have any other questions, Your Honor.
Could I ask a couple?
Go ahead.
I just want to clarify, that was on June 15th, 2023, is that correct? Mr. Capillo?
Uh, I'm not sure exactly which date because it was a whole year ago, but I
Okay.
know it was somewhere in that time frame between June.
Okay. And that Cliff Buick is here in the city of Adrian, is that correct?
Yes, ma'am.
And while this case was pending, did you fail to appear at some point in court and in fact commit other offenses of a similar nature while out on bond
No.
that you've been convicted of?
I didn't commit any new charges, any new offenses from being on bond prior to that case. I was already on bond for a bundle of cases. So I've been sentenced on those cases,
So you're saying
and I
this
haven't.
Jeep was after the Kent County case?
Well, I ended up catching all of these at one time because these cases all came from me being caught with a pro pad in Firekeepers at Firekeepers Casino.
Okay.
And when that device was apprehended, they extract VIN numbers off of the device. And that's when different counties started picking up cases.
And that device is what you use to get into these vehicles, is that correct?
Yes.
Okay. All right. I'm satisfied with the factual basis.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Glazier?
Yes, Your Honor.
All right. I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Capillo has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding possibility of plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we have discussed it on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for January 10th at 8:15 a.m.
Mr. Capitello, do you want to be in person for that sentencing, or would you waive in person and appear via Zoom?
Yes, I would rather appear Zoom.
Okay, I will prepare a Zoom writ.
Thank you very much.
Let me just make sure we have fingerprints. We do have fingerprint information in the file, so Zoom appearance is fine for that.
Thank you.
Okay, Mr. Capillo, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
All right, so you are all set for today. Thank you.
Thank you very much.
Thank you, Phoebe. Thank you, Your Honor.
Okay, Ms. Underwood, do you need to speak to Mr. Let's see who we have for you, Mr. Delaney? Ms. Underwood, do you need to speak to Mr. Delaney?
Just for a brief minute, Your Honor.
All right, Mr. Delaney, I need you to unmute your device.
Okay.
And I'm going to put you in a breakout session with your attorney so that you can speak to her privately.
Okay.
Okay, Mr. Mawad, are you ready to proceed with Mr. Sherwood?
Yes, Judge. I'm going to be right back with you, Mohammed. Yes, Judge, we're ready.
Okay, 1 second. This is file 24-21855-FH, People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, on behalf of the people.
Your Honor, good morning. Elias Mawad, appearing on behalf of Mr. Charles Sherwood.
All right, and Mr. Mawad, where do we stand with Mr. Sherwood's case today?
Judge, Ms. McClure and I have had extensive conversations. There is a final offer made. I have not had time to discuss with Mr. Sherwood. It's nobody's fault. I'm just preparing for my last CSE trial next week. Can I ask for one more date in early January, Judge, if that's permissible? And I can talk to Mr. Sherwood. If you want to set this for a pretrial and a trial, that's fine too, whatever the court would like to do.
Just because I would hope to get a resolution on the case, but in the event that we don't get one, my trial docket's getting kind of full for next year. I would kind of like to get a date for this on the books so we don't get it pushed out even more.
Okay, I think that's reasonable. We are at 154 days on this one. So if it does get tried, how many days, how much time will we need?
I'm not sure how many witnesses Mr. Mawad might have, but for myself, probably 2 days.
I would say that. I don't think I would have more than 2 to 3, Judge, on my end. I'm just thinking out loud, I guess, in my brain. But 2 to 3 probably, if the trial goes.
So Ms. Clark, can we have a 3-day jury trial date then?
Yes, Judge.
And then Charles, we'll have a conversation either later on in the week or weekend, but it's not your fault. It's just preparing for another trial.
And then if we could also get a pretrial in January, just in case so I know whether the offer's being accepted or rejected.
Tuesday, March 11th at 9 a.m., Wednesday, March 12th at 10:30, and Thursday, March 13th at 9 a.m.
I'm available then.
Yeah, I'll be back from, I hope to be on a vacation in February, but I'll be back.
So March 11th at 9 a.m., March 12th, 10:30, March 13th at 9. So let's do a final pretrial on March 5th. And then, I'm sorry, Ms. McClure, you had asked for another pretrial sometime earlier, is that right?
Yeah, if we could have a pretrial in January, just so we know whether the offer is being accepted or rejected, because if it is being rejected, then I do need to address bond conditions.
Okay, so let's go with about January 2nd at 8:50.
Is that enough time, Mr. Mawad? I know you have that
Yeah,
trial.
oh, yeah, it'll be enough time. My trial next week will be a whole week, and then, you know, I know things kind of slow down, but Mr. Sherwood did call me to discuss, and I have not had a chance to get back to him, so I do owe him a call. But yeah, that should be plenty of time. He's been a good client as far as communication.
And Judge, you said January 2nd. Are we doing pretrials on Thursday that week?
I said 22nd.
Oh, I'm sorry. I heard 2nd. Okay.
I heard second too. It's okay.
Okay. I just saw that was a Thursday and it caught my eye, so.
All right. And Mr. Mwad, if you speak to Mr. Sherwood and there is a resolution reached, you're welcome to call and move that up if we have a Wednesday morning available.
Very good, Judge. Would you like an order on the final pretrial date and the trial dates?
I will issue a scheduling order that we will send out that has all of those dates in it.
Very good, Judge. Very good, everybody. Have a good Thanksgiving, everybody, okay?
Okay, thank you, you too. So Mr. Sherwood, you can log out. Your next date is January 22nd.
Thank you very much.
Okay, Mr. Murphy, I have Mr. Raymond from the jail. Do you need to speak with him?
I don't, Your Honor. I think we're ready to proceed on the record when the court's ready.
Okay. All right, Ms. Underwood, are you ready to proceed with Mr. Delaney?
Yes, Your Honor. Thank you.
All right, let me do that one first. So this file 24-21828-FH, People versus Ryan Robert Delaney. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Messer.
Good morning, Your Honor. Ashley Messer, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Delaney this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Delaney's case today?
Yes, I've discussed this matter with my client and with Ms. Messer, Your Honor. And my client is making payments. His job is seasonal, so he's looking for more employment, Your Honor. But under the circumstances, I believe a 60-day adjournment would be appropriate in this matter. And I don't believe the Attorney General's office would object to that, Your Honor.
All right, Ms. Messer, is that accurate?
That is, Your Honor. We were hoping to give the opportunity for the defendant to make some more payments and get a little pattern of payments going, and then I think we can probably resolve this case.
60 days would be end of January. I can do January 29th at 8:15.
January 29th.
Correct.
And I will be happy to do the stipend order with Ms. Metzer's permission.
Yes, absolutely. Thank you. And that date is perfect.
Okay. All right, so Mr. Delaney, your next date is January 29th at 8:15 a.m. You'll log back in using all the same Zoom information you used today.
Okay.
All right, so you're all set. You can go ahead and log out.
Thank you.
All right, and let's see, Mr. Murphy, ready to proceed with Mr. Tucker?
I'm sorry, Your Honor, Mr. Raymond?
I'm sorry, Mr. Raymond. We are on the record now in file 24-21807-FH, 24-21808-FH, 24-21890-FH, 24-22042-FH, and 24-22043-FH. All of these are set for a pretrial conference this morning, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayanetto?
Good morning, Your Honor. Alex Bayanetto for the people.
Matthew Murphy, appearing on behalf of Mr. Raymond.
All right, and Mr. Murphy, where do we stand with Mr. Raymond's case today?
Your Honor, I was speaking with my client yesterday and discussing the matter with the people. At this point, we had discussed a plea offer, and we're trying to figure out if there's an agreement in regards to sentencing in the matter. We're asking if we could adjourn the case for a couple of weeks, or if it's the court schedule best. We're trying to see if there can be some agreement between the defense and the people with a sentencing agreement, and if not, possibly try to find some time to talk with Your Honor about it in a COPS conference. So again, we're asking to adjourn the case because of that. We believe this can be resolved short of trial. It's just this matter of whether or not there can be some sort of agreement about the sentence before we enter a plea.
Mr. Bayanetto, anything to address from the people's side?
No, Your Honor. I think everything Mr. Murphy said is correct. I think we have a resolution in place. It's just a matter of where we land on guidelines and things like that. So I think a brief adjournment would give Mr. Sneed and myself some time to run guidelines and potentially figure out a resolution in this case.
All right, so what I'll do is set it for December 18th at 8:15 a.m.
Yes, Your Honor.
Mr. Murphy, would you do the stipulation and order for that adjournment?
I will, Your Honor.
Right. I will say at this point, the oldest of his cases is at 218 days. So we need to have if we don't have a resolution at that December 18th pre-trial, I'm going to set the oldest case for trial at that time because we need to move the old ones forward.
We understand, Your Honor. Yes, we do apologize for the length of time this has taken. That's why, I do believe it. Just that one adjournment will be sufficient to have it resolved. Thank you.
Okay. Okay, Mr. Tucker, you can let the officer with you know that you are done with court for today.
Mr. Raymond, sorry.
I'm sorry, Mr. Raymond.
Thank you, Your Honor.
All right, and then Mr. Dagger Margosian, are you ready to proceed with Mr. Tucker?
Yes, Your Honor.
Okay, this is file 23-21414-FH People versus Lucas William McGraw Tucker. We are here today for a final pretrial conference in this case, as well as a pretrial on a contempt of court. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, may have the people filling in for prosecutor of record Isaac Sneed.
Your Honor, Michael Dagger Margosian for Mr. Tucker.
All right, and Mr. Dagger Margosian, where do we stand with Mr. Tucker's case today?
Your Honor, Mr. Sneed and I have reached a resolution. There should be an amended information in the court's file. At this time, Mr. Tucker will be pleading guilty to an added count of added count 2 of disturbing the peace. In exchange, count 1 will be dismissed, as well as there's a sentence agreement for credit for time served only in this matter. We're ready to proceed with that.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
I believe so, yes.
All right, Mr. Tucker, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Lucas William McGraw Tucker?
Yes, Your Honor.
Mr. Tucker, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information disturbing the peace?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 90 days in jail?
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes, absolutely.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it here this morning. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Mr. Tucker, did you hear me?
Yes. Yes, Your Honor.
Okay. Did you understand that last question?
Yes.
Okay. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting, you have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Tucker, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you are giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about November 24, 2022 in Rollin Township, Lenawee County, Michigan, you did commit the offense of disturbing the peace?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Tucker to plead guilty today?
None, Your Honor.
No, Your Honor.
Mr. Tucker, other than as we've discussed on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Dagger-Margosian, do you want to cover the factual basis?
Mr. Tucker, on November 24th of 2022, as the court indicated, were you in Rollin Township, County of Lenawee, State of Michigan?
Yes.
And on that date, at an address on Glen Hill Highway, 1524 Glen Hill Highway, would you agree that you were loud and boisterous in public?
Yes.
Okay. And you didn't have a legal right to do so?
No.
All right. I think I'm satisfied, Your Honor.
Ms. McClure?
I just think we have to put on a factual basis for the restitution in order for that to be ordered. So I guess I would just ask for stipulation as to the underlying charge, and with an agreement that there is restitution as to, be towing and replacing the key of a motor vehicle that was taken.
If that is verified, I mean, part of what Mr. Sneed and I were going back and forth on this case is the restitution. So if it's verified, that's certainly fine.
Okay. So do you stipulate that that is the underlying and there could be restitution?
For purposes of the plea, yes, I agree that there could be restitution if verified factually.
All right, I'm not sure I hear an agreement here. So are you admitting to the facts that would support restitution, or are you not admitting to those facts, Mr. Dagger-Margosian?
Well, I would be admitting, my client would be admitting to the facts of disturbing the peace with the understanding that if facts are presented to the court or the prosecutor's office regarding restitution, that could be included in this case.
So I interpret that as a no.
As to count one, the fact of count one that he took a truck, correct. But as to count two, the disturbing the peace, yes, we are moving forward with, and that is the plea deal.
So you can admit the facts of it and still set it for a restitution hearing. It's a plea reduction from what the underlying basis of the disturbing the peace was.
Yes, and there was an allegation of damage to a vehicle. The question is if he made it. So if we need to have a restitution hearing, that's fine. But I don't think that affects the plea of this.
So, okay, I guess, Judge, maybe we just set it for a restitution hearing, and I'll make a note that the underlying facts supporting restitution have not been established. I don't know, typically the facts are established and it's just the amount that's in question. So that's why I'm kind of thrown, I'm sorry.
All right, if that's how people want to proceed, I mean, I'm just trying to make sure that there's a clear understanding of what the agreement between the parties is. So,
Judge, if the agreement between Mr. Sneed and I was that he would plead guilty to count two, disturbing the peace, credit for time served. And I know that there had been an issue of restitution previously. But again, if the people are, if there needs to be a hearing to determine restitution, then so be it.
That's fine. I'll have Mr. Sneed request it if that's what he wants. And if he doesn't, then it won't be ordered.
right. All right, has the court complied with MCR 6.302 B, C, and D, then Ms. McClure?
It has.
Mr. Dagger-Margosian.
Yes, Your Honor.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Tucker has had full knowledge of his rights. He had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation. That'd be the district court probation office. And we'll set sentencing for January 16th at 8:15 a.m. Mr. Tucker, you'll need to report to Mike McCarron in the district court probation office on this coming Tuesday, December 3rd at 8 a.m.
December 3rd, okay.
Okay, so you are all set, Mr. Tucker. You can go ahead and log out.
Awesome, thank you.
Mr. Glazier, I have Mr. Imer here in the courtroom. Do you need to speak to him?
Good morning, Kelly again, and Judge Wilson. We have Karesa Edwards at a room for the judge.
Your Honor, Mr. Imer was supposed to come in to see me. I think you indicated we had to set it for trial today.
I just need to know if you need to speak to him or not.
No, I don't.
One second. Okay, I have someone here from an MDOC facility. Can you tell me your name, please?
Ted Weston Till.
Okay, Ms. Underwood, you need to speak with Mr. Till. Ms. Underwood, are you there?
Sorry, I forgot I was muted. Yes, Your Honor, thank you.
Okay, Mr. Imer, do you want to come forward to the podium, please? All right, we are on the record in file 24-21792-FH, 24-21872-FH, and 24-21873-FH. People versus Bailey, Assad, and Imer. We're here today for pretrial conferences in each of those cases, and we are proceeding today by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
E.V. McClure, on behalf of the people.
John Glazier on behalf of Mr. Nimer.
And Mr. Glazier, where do we stand with Mr. Nimer's case today?
Your Honor, I guess we need to set it for trial. Mr. Nimer was supposed to come in and see me last week and didn't appear. I really need to talk to him, but I think we stated at the last one that there would be no more adjournments, so if we get a pretrial of 60 days out at least.
So the oldest file would be the 24-21792-FH file. Mr. Glazier, how much time or how many days do you think we need for a trial in that case?
Probably 2.
Do you agree with that, Ms. McClure?
Yeah, I don't have any intimate knowledge of the case, just because it is Mr. Sneed's case. So, John, do you know if there's any chance of these being consolidated?
Maybe one of them, but we'd have to agree to it. I think, isn't there 3 files?
There are,
That's
yeah.
correct.
I would just defer to Mr. Glazier then. I guess I would agree with him.
And I'm sorry, did you say 2 or 3, Mr. Glazier?
I think between 2 and 3. I
So
think
let's go.
I think really it could get done in 2 days, but it might take part of a third day.
All right, so we'll set it for 3 days to be safe. Ms. Clark, can we have a 3-day jury trial date, please?
Tuesday, April 1st at 9 a.m., Wednesday, April 2nd at 10:30, and Thursday, April 3rd at 9 a.m.
Your Honor, whenever you have a minute, if I could.
Okay, 1 second.
No problem.
That was April 2 through April 4.
April 1st.
April 1st, 2nd, and 3rd.
Okay.
All right, and Mr. Glazier, Mr. Nimer had asked to address the court directly. Do you have any issue with that?
No.
Okay, Mr. Nimer, what was it that you wanted to say?
Your Honor, I've just had a little bit of trouble as far as the representation that I've been given. I just feel like I haven't been given the proper legal representation. I brought things to my attorney's attention, and it seems that they've been kind of neglected in a way. I don't know exactly how this process works. I've never been through the court process before, but it just seemed that there's something different that we could do, because I was made promises at the beginning, months ago, as far as waiving examinations and pretrials. And like I said, Your Honor, I'm very unfamiliar with the process. And I was told from the very beginning that there would be no gun charges, that they would be dropped as long as I was willing to work with the prosecutors, waive examinations, waive preliminary hearings. I did all of that. And then it was told to me after waiving all of these things that they do not recall saying they would drop certain charges if I did so. And it's all just been kind of a very high stressful anxiety mess for me, as far as trying to figure out who I can trust when something's told to me, when my attorney tells me this will be dropped if you do this, and that he spoke with the prosecutors, and I do my part and then come around to say that they don't remember saying those things. It's just, I just don't feel that I have been represented in the best way, for a lack of better words.
All right, so are you claiming that Mr. Glazer should have done something that he has not done, or what is your
Yes,
issue with the
there's-
representation?
Well, as far as telling me that if I waive something and that then this would happen, and then those things were taken back. The exact words was that Mr. Sneed claims to not remember saying those things to Mr. Glazer. I don't know exactly how it works or how when an agreement is made, if it's set in stone. Like I'm not exactly sure how that works. However, there was that part. There's other things I brought up as far as things I wanted him to see on my body cam footage and other, just from speaking to another attorney friend who had brought some points up on the body cam footage and things that had been looked at. There's just been quite a few issues as far as many things just since the very beginning, and I just feel that maybe if I should, and I mean if I know disrespect.
All right, so I can't just assign you another attorney.
Okay.
I can. There's a process. If you're claiming that Mr. Glazer has been ineffective, then I have to hold a hearing and explore that further and make a determination as to whether he's been effective or whether your disagreements with things he has done or not done are a legitimate part of an attorney has a certain amount of discretion to determine certain things,
right?
In terms of strategy and that kind of thing. And so I can set this for a hearing to determine to hear evidence and make a determination on whether he's been ineffective. In which case the court would then have to remove him. If that's what you want me to do.
As far as setting for trial today, the whole idea was to try to come to some type of an agreement, plea agreement, and as far as
okay. So have you been to see Mr. Glazer?
Yes, I have.
When did you do that?
I've seen him maybe 4 times.
When was the last time you did? Did you do it since the last pretrial?
The last time I saw him was.
Did you do it since the last pretrial?
Since the last pretrial, yes. I saw him on the 21st.
Your Honor, he had an appointment to come in and see me, I think last Friday, and didn't appear. There's certain things that I need to review with him, but if he doesn't show up, I certainly can't review them with him. I don't know why he didn't appear for his office appointment.
Right. So again, so Mr. Imer, you've expressed some dissatisfaction. If you want me to schedule a hearing to determine whether or not Mr. Glazer has been effective or ineffective, I can do that. So do you want me to do that?
Yes, please, Your Honor.
Judge, could I make a brief record before that happens?
Go ahead.
I think some of the issues that Mr. Imer addressed with the court have stemmed from this waiver of the preliminary exam. And just for the record, when a preliminary examination is waived in district court, they make a record that if were you promised anything and is this a voluntary waiver? And we do believe, and we just for the record believe that those elements have been met and the waiver was an appropriate waiver without defect. However, if he is now saying he was promised something in exchange for the waiver of his preliminary exam to cure any possible defect, we would stipulate to a remand for a preliminary exam to then cure any defect that is now being claimed, if that is more appropriate.
May I speak on that, Your Honor? As far as
no. So right now you're representing, and the only thing I'm going to do right now is
set a hearing.
What I'm supposed to do, and that's set a hearing to make the determination as to whether Mr. Glazer's representation has been effective or ineffective, and the court will proceed from there. So Ms. Clark, I'm going to need a hearing date for I guess let's call it about 2 hours for a Ginther hearing.
Friday, December 13th. Yeah, December 13th at 1:30.
Our office is unavailable that day, or that afternoon, I'm sorry.
Wednesday, December 18th at 2:30.
Just since Miss Bergman's on, Miss Bergman, are you available on December 18th in the afternoon?
Or, I'm sorry, why would I be on this case?
Just for a Ginther hearing.
Oh, I think because it's still in the trial court, that would be Mr. Sneed.
Okay,
Would still be doing that because it's not post conviction.
okay, then I think we're available.
Okay,
Was that
so Mr. Glazer, are you available at that time?
I'll be available, yes, Your Honor.
December 18th at 1:30 p.m. So we will set for a Ginther hearing on December 18th at 1:30 p.m. A final pretrial for, March 19th at 8:30 a.m. I'm sorry, 8:15 a.m.
That was
And
March what,
trial-
Your Honor?
Final pretrial, March 19th,
Okay,
and then trial on April 1st, 2nd, and 3rd.
okay,
Depending upon what happens at the Ginther hearing, the court would be perhaps willing to reconsider the trial date. But for now, we're going to put it on the calendar.
all right.
And the court will issue a scheduling order with those dates in. Is there
Mr.
anything else?
Nimer, if you want to come in and see me and set up an appointment, if you show up, we can discuss this case.
All right. All right. Anything else we need to address on this case today?
No, Your Honor.
Thank you. Then, Mr. Nimer, you're all set for today.
Thank you, Your Honor.
Oh, yes. Yes, thank you.
Your Honor, was that December 13th that you said? Or was it 18th?
18th.
18th, okay, thank you.
Did I hear this one? So please. Okay, Mr. Dagger Margosian, do you need to speak with Ms. Edwards?
Yes, please, Your Honor.
1 second. Okay, Mr. Malero, are you ready to proceed with Mr. Sadler?
We are, Your Honor.
This is file 24-22009-FH, People versus Arnette Sadler III. We are here today for a trial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready. Salvatore Malero on behalf of Arnette Sadler.
Okay, and Mr. Malero, where do we stand with Mr. Sadler's case today?
Your Honor, Mr. Sadler was in my office yesterday. I know we had requested he be screened for Veterans Court. I don't know the result of that. Does the court know?
I don't believe that has happened. Let me check one thing to be sure.
In case you met with someone right now.
It does look like he was screened and approved for Veterans Court.
Great. Your Honor, with that information, I'd like to adjourn this for a brief adjournment to talk to Mr. McCready, see if this matter can be resolved. You said approved, right? Yes.
Okay, so I can adjourn it to December 18th. Is that sufficient?
That's fine, Judge.
December 18th at 8:15. I'm sorry, Mr. McCready, anything we need to address from the people's side?
No, Your Honor.
Okay, so December 18th at 8:15 a.m. Mr. Miller, would you do that stipulation in order, please?
Yes, I will, Your Honor.
All right, anything else we need to address on this one today?
No, Your Honor.
Thank you. All right, Ms. Underwood, are you ready to proceed with Mr. Till?
Yes, Your Honor, thank you.
Thank you.
All right, this is file 24-22008-FH, People versus Chad Till. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Ms. McClure?
A.B. McClure, on behalf of the people.
Rhonda Underwood on behalf of Mr. Till, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Till's case today?
Your Honor, we believe we have successful plea negotiations with the prosecution, but we're just firming up the paperwork and details, Your Honor. And we would be grateful for a short adjournment, perhaps the beginning of January.
Ms. McClure, is that agreeable to the people?
Yes, I just need time to do an amended information plea form, and it's kind of a busy docket this morning for me to try and do it.
Okay. Is January 8th at 8:15 all right?
That works for the people.
What was that date, Your Honor?
January 8th?
That's fine, thank you. And I will be happy to do this stipulation with McClure's approval.
Judge, should that be in person or on Zoom? I don't know if we have fingerprints or not.
Mr. Till, do you want to be here in person or on Zoom?
In person.
Okay.
All right, so Mr. Till's request to be in person, so if we get an in-person writ, let me check on the fingerprint situation.
That works out great.
We do have fingerprints, so that's not necessary at this point, but he's requested to be here in person, so we could have an in-person writ. So, all right, so Ms. Underwood, you're gonna do the stipulation in order. Anything else we need to address with this case today?
Nothing on behalf of the people.
Nothing, Your Honor.
Okay, thank you, Mr. Till. You can let the officer with you know that you're done with court for today.
Okay, thank you.
What's your name?
Yeah, it's with Mr. Millar.
I'm sorry.
He's gonna be Judge Jason Lindsay.
Jason.
Oh, okay. Are you ready to proceed with Mr.
Yeah,
Lindsay?
we have a plea to put on, Judge.
All right, we can do that then.
Should be, you should have it in your file. Report.
Okay, this is file 24-21749-FH. People versus Jason Floyd Lindsay. We are here today for a pretrial conference. In this case, we're proceeding today by video conference and in person. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Salvatore Malera on behalf of Jason Lindsay.
All right, and Mr. Malera, where do we stand with Mr. Lindsay's case today?
You know, we did reach resolution in this matter and should have sent the plea form to the court yesterday. Mr. Lindsay is going to plead guilty to reckless use of a firearm, a 93-day misdemeanor. I believe the, trying to pull out the form now. Further the sentence agreement, no immediate jail, and forfeiting of the firearms and any ammunition. So give me a second here. So they had a count 3 reckless use of a firearm. You're under MCL 752.8638. No immediate jail. All felony counts to be dismissed. And the defendant to forfeit the firearms, the magazines, and any ammunition. And that was submitted to the, well, I think I had it sent over yesterday. That is our plea agreement, Judge.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
Mr. Lindsay, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Jason Floyd Lindsay?
Yes.
Mr. Lindsay, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3, reckless use of a firearm?
Yes.
Do you understand that the maximum possible penalty for that offense is 90 days in jail and or a $500 fine?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given?
I am.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed on the record here today. Is that correct, Mr. Malero?
That is correct, Judge.
Ms. McClure?
That's correct.
Is that also your understanding, Mr. Lindsay?
It is.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Lindsay, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I understand.
And you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yeah, I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about February 25th, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of reckless use of a firearm?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were disclosed to court on the record this morning, or that it was not your own choice to enter the plea? Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Lindsay to plead guilty?
No.
None, Your
No,
Honor.
you're.
Mr. Lindsay, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Malero, would you like to cover the factual basis?
I would. Mr. Lindsay, is it true that on or about February 25th in the city of Adrian, county of Lenawee, state of Michigan, that you were brandishing or using a firearm in your possession in a reckless manner?
Yes.
And it resulted from you and your wife were having a disagreement in some capacity. You were had possession of the firearm, and you caused your wife to believe that you may use the firearm in some capacity, and that caused her distress.
Yes.
And there was alcohol involved in the situation.
Yes.
Is the court and the state satisfied?
Ms. McClure, are the people satisfied?
Yes, Your Honor.
Has the court complied with MTR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Malero?
Yes, Judge.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Lindsay has had full knowledge of his rights. He's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we discussed on the record this morning. I will refer this matter to the District Court Probation Office for a pre-sentence investigation. And we will set sentencing for January 16th at 8:15 a.m. So, Mr. Lindsay, you'll need to report to the District Court Probation Office to see Mr. McCarron this coming Tuesday at 8 a.m. To do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Your Honor, may we address bond on this matter?
Yes.
Mr. Lindsay's been ordered to undergo PBTs, I think, since the inception of this matter. Spoke to Mr. Coast yesterday. It's my understanding that he's done pretty well on that, and we asked that the requirement be terminated. I'll further discuss with Mr. Coast. Mr. Lindsay has a couple of trips, one for a job interview, one for I think a vacation plan with his wife. To the state of Florida, I would ask the court upon documentation of Mr. Coast that he'd be allowed to travel out of state for that purposes as well.
All right, Ms. McClure, anything you'd like to say with respect to the issue of the bond request?
I would just defer to Mr. Coast.
All right, Mr. Coast.
Judge, he's done pretty well on bond. He's been doing PBTs 2 times a day since February. I just checked his log. He's been doing it twice daily without missing, with the kiosk with 000s each time. He does owe JSG $249 for when he was on the remote breath. He did return that machine, but he does owe them that money. But because of his efforts, I mean, I'll be okay with him going off PBTs.
So I will make that modification to eliminate the PBT requirement and admit the out-of-state travel for the job interview and the vacation. Mr. Lindsay, you need to give your dates of travel and your locations to Mr. Coast before you leave. Okay, so we're all set. Then we'll see you back on 16th. Let me just make sure we have fingerprint information.
And Jason, you have my information, my phone number?
Yes, I do.
Okay.
We're all set then with the fingerprint information. Mr. Miller, do you know what Mr. Lindsay wanted to do with the contempt?
Was that the somehow missing on PBT here?
I think that's what it seems like. Fine.
There was some issue about it.
Judge, he did have a contempt back in August for missing PBTs. Ever since then, he has done pretty well. So my suggestion is that we go ahead and dismiss that contempt.
Okay, I will do that then. We'll dismiss the contempt charge.
Thank you, Judge.
Okay, I think we were all set then.
Great, thank you, Your Honor.
Thank you. Okay, Ms. Freeman, Mr. Lyons, you need to speak to Mr. Fenton.
Your Honor, I'm just sort of along for the ride here. Ms. Fenton is actually handling the appellate matter.
I do not need to meet with Mr. Fenton, no.
Nor do I.
Okay. This is file 18-19189-FC, People versus Michael Davis Fenton. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brugman? Ms. Brugman, I apologize. We did not hear anything that you said.
Can you hear me now?
Yes.
Oh, sorry. Must have been a delay. Jennifer Brugman on behalf of the people.
Melissa Freeman on behalf of Michael Fenton.
May it please the court, George Lyons on behalf of Mr. Fenton.
And so where are we with Mr. Fenton's case today?
Your Honor, I could probably speak to that. The interlocutory appeal was filed by defense on October 24th. I filed our answer on November 14th. When I filed that, I sent in a zip drive of the interview for the court to review, for the Court of Appeals to review. They emailed me and Ms. Freeman on November 21st, letting us know that they could not open it with the player that was given to them. So we've had IT try to do it, and that has not been successful. Currently, I'm having Lamar Ruffner from the agency look to see if he can do it. They need it in an MP3 or MP4 format, and so that's kind of where we're at. I'm hoping to that Lamar Ruffner can do that today and get it back out in the mail to the Court of Appeals. But that's kind of where we're at. And then, of course, the Court of Appeals needs to decide whether they are going to grant the application or not. If they grant it, then obviously it will be delayed further, because then the parties have the ability to file further briefing or what have you. If they deny it, then obviously we would be back in the trial court.
All right, Ms. Freeman, anything to address from the defendant's side at this point?
No, everything was correct, and that's my understanding of what's going on.
Okay, why don't we adjourn this then until I could do December 18th or January 8th. There's kind of a long break there because of the holidays, so I'll give you the option.
I have no objection to the January date, Ron, just to make sure that all our ducks are in a row, one way or the other.
Yeah, quite frankly, Your Honor, just knowing how these things go, unless they immediately decide and do not grant, I don't expect much to happen before the holidays.
Is that agreeable with you, Ms. Freeman?
Yes, I didn't catch what that January date was, however.
That was January 8th.
Yeah, that works for me.
Okay, so we'll set that for January 8th at 8:15. Ms. Brugman, would you be willing to do a stipulation in order for that adjournment?
Your Honor, and then we also, I assume, do a Zoom writ for Mr. Fenton.
Mr. Fenton's at the Lenawee County Jail, so we don't need that.
Oh, I apologize. I forgot that. Okay, thank you.
No problem. Okay, so I think we're all set then. Thank you, Mr. Fenton. You can let the officer with you know that you're done with court for today.
Okay, what time is that going to be on the 8th?
That will be at 8:15.
Thank you.
Or as soon thereafter as I can call the case.
Okay, thank you, sir.
Yes, thank you. All right, Mr. Daly, are you ready to proceed with Mr. Dufty?
Yes, Your Honor. It's going to be a plea, Your Honor.
Okay. All right, this is file 24-21984-FH, People versus Andrew Wayne Dufty. We are here today for a pretrial conference. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, the people filling in for record, Alvin Arnold.
James Daly on behalf of the defendant.
All right, and Mr. Daly, where do we stand with the case today?
He's going to plead guilty as charged. There's an agreement that he will be sentenced to no more than a term in jail. That's to be decided afterwards, but that's basically the deal.
Wait, could you state that again? I'm sorry.
He's going to plead guilty and the prosecutor, did you get a notice of the agreement, Phoebe?
I did. I just couldn't hear you. I'm sorry.
Oh, okay. Yeah. We're prepared to plead guilty right now. We pleaded guilty as charged without any additional supplements, with an agreement that he won't be charged for any of their crimes that they're aware of right now and investigating. And he'll enter his plea today.
Okay, I believe you also said, Mr. Daly, that there was an agreement that the sentence would be no more than 1 year in jail. Is that correct?
It is.
Okay, so Ms. McClure, is that a complete and accurate statement of the agreement?
I mean, I don't know if it is, but I don't know if it's just semantics. The agreement would be to sentence within guidelines, and the guidelines right now are to jail. So I think it would be a sentence to jail, not just no more than.
Ms. McClure is right.
Okay. All right. I just want to make sure that's clear so we don't get to sentencing and there's an issue.
Guideline sentencing, but the plea agreement indicates it's for jail only. And we still have the ability, we will argue for less time, and the prosecutor, I know, is going to argue for a year in jail. So that issue about the ultimate disposition is still up in the air, but we're ready to plead right now.
That's my understanding too. I just wanted to make sure there was no misunderstanding.
Yeah.
Okay. All right then, Mr. Dufty, would you need to get you on camera here first, if you could. Okay, would you raise your right hand, sir? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Andrew Wayne Dufty?
Yes.
You can put your hand down, and I need you to speak a little louder.
Yes, Your Honor.
Mr. Dufty, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of child sexually abusive material?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $10,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Daly and the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure? Or, I'm sorry, other than as we've discussed it here today. Is that correct, Ms. McClure?
That is correct.
Mr. Daly?
Yes, Your Honor.
Is that also your understanding, Mr. Dufty?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Dufty, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about July 10, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of possession of child sexually abusive material?
Guilty.
You gotta speak up.
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that by entering the plea to this offense, you will be required to register under the Michigan Sex Offender Registration Act?
Yes, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Dufty to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Dufty, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what it would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Daly, do you want to cover the factual basis?
Yes, Your Honor. Mr. Duffy, on July 10th of 2024, were you present in Madison Township?
Yes, Your Honor.
And at that time, did you have some images of children on your phone?
Yes.
Okay. And you know that it's illegal to have those type of images?
Yes.
All right. And you knowingly possess those images?
Yes.
Okay. I have no other questions at this time, Your Honor.
Just to clarify, the images, were they of nude children?
Yes.
And were they sexual in nature?
Yes.
And you knew they were on your phone?
Yes.
Okay. People are satisfied, Judge.
Okay. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Daly?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Dufty has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 16th at 8:15 a.m. Mr. Dufty, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
And Judge, we're requesting an in-person sentence on that day and not via Zoom, or that the defendant not appear via Zoom.
We understand that, Your Honor.
Thank you.
So that sentencing date be in person.
I'm sorry.
Mr. Stevenson, do you need to speak to Mr. Dufty?
Yes.
Okay, so I'm going to put you in a breakout session real quick with the probation officer so he can get your contact information.
You can just run over to that. Yeah, because I put it over here.
Yeah, and so it's like people try to transfer.
Tell us where they want us to meet him.
Okay, Mr. Dagger Margosian. Looks like he had logged out. Ms. Underwood, I don't have Mr. Case here and have not all morning. Have you had any correspondence with him?
There we go.
All right, Ms. Messer, I apologize. It looks like Ms. Underwood is logged out for a moment. We'll proceed with Mr. Case as soon as she gets back.
Thank you.
Okay, let's see. Mr. Daly, are you ready to proceed with Mr. Edwards?
Yes, Your Honor. I'll talk to you later. Okay.
All right, so this is file 24-21785-FH, 24-21781-FH, 24-21782-FH, 24-21783-FH, 24-21784-FH, and 24-21972-FH. All people versus Nathan Wayne Edwards. We are here today for a pretrial conference in these cases, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
James Daly on behalf of the defendant.
All right, and Mr. Daly, where do we stand with Mr. Edwards' cases today?
Mr. Edwards wants to enter a plea today. A plea bargain has been reached. The plea offer is that if he pleads guilty to count 1, possession with intent to deliver methamphetamine, and count 6, felony firearm, there's an agreement of 24 months MDOC consecutive 51 to 240 months for a total of what would be approximately 75 months with everything.
Okay, Mr. McCready, is that a complete and accurate statement of the plea agreement?
He'd be pleading to those charges on file ending in 8-5. He'd also be pleading guilty to 4 counts of resisting and obstructing on the file ending in 7-2. And we've agreed that the sentence on the resisting and obstructing charges would run concurrent to the sentence on count 1 in the other file, the P-Wade methamphetamine.
Okay, is that correct, Mr. Daly?
Yes.
All right, Mr. Edwards, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Nathan Wayne Edwards?
Yes, I am.
Mr. Edwards, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 24-21785-FH to count 1, possession, delivery or manufacture of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense up to 20 years in prison and or a $25,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty in that file to felony firearm?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is, or the penalty for that offense is 2 years in prison that is consecutive to and preceding any other term of imprisonment?
Yes, Your Honor.
Is it also your intention to plead guilty in file 24-21972-FH to count 3, assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
And is it also your intention in that file to plead guilty to count 4, a second count of assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
And is it also your intention to plead guilty to count 5 in that file, a third count of assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
And is it also your intention to plead guilty in that file to count 6, which is a fourth count of assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for each of those counts of assaulting, resisting, obstructing a police officer is up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
I'm sorry, are you satisfied with Mr. Daly and the advice he's giving?
Yes, Your Honor. I'm sorry.
Okay. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Other than as we've discussed on the record today? Is that correct, Mr. McCready?
Yes, it is.
Mr. Daly?
Yes, Your Honor.
Is that also your understanding, Mr. Edwards?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you to make sure that you understand. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent, and until you're proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Edwards, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
I do.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, Your Honor.
Do you understand you're giving those rights up?
Yes, I do.
How do you wish to plead then in file 24-21785-FH to the charge that on or about January 10, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of delivery or manufacture of methamphetamine?
Guilty.
And how do you wish to plead in that same file that on the same date and location you did commit the offense of felony firearm?
Guilty.
In file 24-21972-FH, how do you wish to plead to the charge that on or about August 13, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of count assaulting, resisting, obstructing a police officer?
Guilty.
And in that same file, on the same date and in the same location, how do you wish to plead to count 4, second count of assaulting, resisting, obstructing a police officer?
Guilty.
And in that same file, on the same date and the same location, how do you wish to plead to count 5, the third count of assaulting, resisting, obstructing a police officer?
Guilty.
And again, in the same file, on the same date, in the same location, how do you wish to plead to count 6, the fourth count of assaulting, resisting, obstructing a police officer?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than this plea bargain to induce Mr. Edwards to plead guilty?
No.
Mr. Daly?
No, Your Honor.
Mr. Edwards, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record this morning?
No, Your Honor.
Your own choice to plead guilty today?
Yes. Yes, Your Honor.
Mr. Daly, do you want to cover the factual basis?
Hello, Your Honor. Mr. Edwards, is it true that on February 5th, I'm sorry, on January 10th of this year, were you stopped police in the city of Adrian?
Yes.
It was actually Madison Township.
Madison Township.
And at that time, you were in possession of methamphetamines?
Yes, I was.
And those are methamphetamines that you were going to deliver?
Yes.
Okay. And did you have a firearm on your possession at that time?
Yes, I did.
Okay. And was it your firearm?
Yes.
Okay. And this all happened in the city of Adrian?
Madison Township.
Madison Township, rather.
Yes,
and
sir.
on August 11th, do you remember being apprehended by the police?
I do.
And when you were apprehended by the police, did you resist them?
I did.
And in what manner did you resist?
I couldn't move my arm, so I was trying to work against them, I guess. Say.
Okay. You were resisting them in the process of them trying to arrest you. Is that correct?
Yes. Yes.
Okay. I believe I have that all covered, Your Honor. I have no other questions.
Mr. McCready?
If I could ask you just a couple. Mr. Edwards, do you know the names of the officers that you were resisting?
No, Your Honor. No, sir, I do not.
Would the defense stipulate that it's Officer Ty Peterson, Officer Sean Street, Officer Eric Gantert, and Officer Joshua Perez?
Yes.
People are satisfied.
Has the court complied with MTR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Daly?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Edwards has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for January 19th at 8:15 a.m. Mr. Edwards, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
I will.
All right, you can let the officer with you then know that you are done with court for today.
All right, thank you.
Okay, Mr. Dagger Margosian, are you ready to proceed with Ms. Edwards?
Yes, Your Honor.
File 24-21766-FH, People versus Karesa Pearl Edwards. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, map of the people.
Your Honor, Michael Dagger Margosian for Miss Edwards.
Right, and where do we stand with Ms. Edwards' case today?
Your Honor, this case was originally scheduled for jury trial. Subsequent to that scheduling, Miss Edwards did miss a court date. A bench warrant was issued. A contempt was issued. I'm representing her on a matter in district court that's pending right now. That is with Mr. Hartung. I'm trying to sort that case out as well. What I would ask for on this case is to, at this current time, reschedule it for final settlement conference, jury trial in the future, and then in between now and then, if I can work out a global resolution with Mr. Hartung on both of these cases, then I will let the court know.
Okay, and we had previously had this set for 2 days. Is that still what we think is sufficient?
Yes. And again, if it changes, I'll let the court know.
Yes, and my preference would just be to wait to get the other case up in circuit court, but whatever the court wants to do.
I would defer to Mr. Dagger Margosian. I mean, I'm happy to set it for trial now if she wants a trial date, or.
Judge, the PCC on the district court case is December 6th, fairly soon. I don't mind setting this for just another pretrial. I expect that case will reach circuit court, and then, like I said, I'll be talking with Mr. Hartung. So I don't have a preference one way or the other.
You guys are funny.
Okay.
And then I get.
Go ahead.
I guess what I'll say is, if at that next pretrial we haven't come up with something, then it would make sense to set this case for trial.
Yeah, and I agree with that.
So I can set it for December 11th, which would be the Wednesday following probable cause conference.
I guess my only concern with that is if we do waive at that point, I don't know if the circuit court arraignment would be before then. What's the week after that, or the next pretrial after that?
The 18th.
If we could do that, I think that's what I would prefer.
Okay, so the 18th at 8:15 a.m. All right, and Mr. Dagger-Margosian, would you be willing to do a stip in order for the adjournment?
I will. I just have one other bond request, if the court would hear me out.
Go ahead.
Your Honor, as I indicated, Miss Edwards was out on bond on this matter at the time of when she was arrested. If I could ask the court to actually impose a small minimal fine so that she is getting jail credit at this time, that would be my request. And I'll also say that she's being held in on bond on the district court matter as well.
Okay. So she's got a bond on this of $10,000, so she should be getting credit already.
Is it bond on the contempt, or is it on the underlying case? If it's on the underlying case, that's.
Yeah, I usually for credit purposes count it if it's a bond on the contempt, but yeah.
Okay.
So, I mean, if you want, I can do $100 bond on the underlying as well.
That's sort of what I was asking, just for technical purposes.
Okay. All right, so we can do that. We'll set a $100 bond on the underlying charge, just so it's clear that she would have credit for any time that she's serving right now.
Thank you, Honor.
Okay, anything else on this one then?
No, I'll do the stip in order.
Okay, thank you. Ms. Edwards, you can let the officer with you know that you're done with court for today.
All right.
Okay, Mr. Lyons, I have Mr. Shears here. Do you need to speak to him?
My apologies, Your Honor. I'm on the laptop I don't usually use. If I may, Your Judge.
1 second.
Well, it's Kelly, Judge's papers. Could we have Jim Justice in, please? Thank you. Bye.
Okay, so this is file 20-20156-FH, People versus Emily and Dietrich. We are here today for a hearing on a summons for probation violation, and we are proceeding today by video conference. Ms., you are Emily Ann Dietrich?
Yes, I am.
And Ms. Dietrich, have you received a copy of the request and summons for probation violation?
I did receive that from my probation officer here in Jackson, yes.
Okay, so that document alleges that you have violated your terms of your probation by failing to pay child support as ordered by the court. You had, in this case, previously pled guilty to failing to pay child support, and the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine. You do have the right to be represented by an attorney with respect to this hearing and any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from our public defender's office. Do you understand that?
Yes.
Do you want to be represented by an attorney today?
Yes.
Do you have the ability to pay for your own attorney?
No, I do not.
Okay, so what I'll do is put you in a breakout session with Ms. Underwood from our public defender's office. If you give me about 5 seconds.
Okay, thank you.
Okay, I have someone here by telephone. Last 4 digits of your phone number are 8073. Can you tell me your name?
Michael Santiago.
Okay, Mr. Santiago, just hold on 1 minute. I will get to your case.
Okay.
Okay, Mr. Miller, are you ready to proceed with Mr. Santiago?
I am, Your Honor.
Okay.
Hello?
Yeah, 1 second, Mr. Santiago.
Okay.
Oh, we left breakout room. Oops. I don't know what happened. No idea what happened.
Okay, Ms. Dietrich, I can't have you talking. It's interfering with our record. Okay, this is file 24-21935-FH and 21-21935. People versus Michael Santiago. We are proceeding today by video conference. We're here for a pretrial. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
Salvatore Malero on behalf of Michael Santiago.
And Mr. Miller, where do we stand with Mr. Santiago's cases?
Your Honor, I noticed in my email yesterday, there was a pretrial or a plea offer. I did not have an opportunity to review it. So I'd ask to adjourn this for me to review it, talk to Mr. Santiago about it. I think we know where we're going.
Mr. Bayonetto, anything to address from the people's side?
No, Your Honor.
Go to December 18th. Is that sufficient?
That should be fine. Sir.
So we'll adjourn this to December 18th at 8:15 a.m. Mr. Santiago, you need to call in on the same date. You'll use all the same Zoom information that you used today.
Okay. All right.
Mr. Malero, would you be willing to do that stipend work?
I would be willing.
Okay. Anything else we need to address with Mr. Santiago's case?
Not from the defense.
All right.
Your Honor, thank you.
Okay, thank you. Mr. Santiago, you can go ahead and hang up or log out.
Okay, thank you.
Ms. Underwood, are you ready to proceed with Ms.
Yeah,
Dietrich?
Your Honor, thank you.
All right, back on the record in People versus Emily and Dietrich. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Ms. Dietrich this morning, Your Honor. Thank you. We would ask the court to enter a not guilty plea on Ms. Dietrich's behalf, Your Honor, and set this out for about a month for a pretrial. Ms. Dietrich has applied for disability, Your Honor, and there are some other issues. So I want a month to get updates on all that and to see where we are at that point, Your Honor, as far as whether payments are a possibility.
All right, I will enter a not guilty plea for Ms. Dietrich. I will set this for a pretrial on January 8th at 8:15.
January 8th at 8:15?
Correct.
Thank you.
Thank you.
So Ms. Dietrich, you'll need to log in on that date with all the same Zoom information that you used today.
Okay. Okay. Thank you.
All right, so you're all set. You can go ahead and log out.
Okay, thank you.
Mr. Dagger Margosian, you need to speak to Ms. Justice.
Yes, please, Your Honor.
Okay, 1 second. And then Mr. Lyons, are you ready to proceed with Mr. Shears?
Yes, I am, Your Honor.
Okay. This is file 24-21752-FH, People versus Frederick Khalil Shears. We are here today for a probation violation hearing. We're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.V. McClure, behalf of the people.
Your Honor, may it please the court, George Lyons on behalf of Mr. Shears.
Okay, and where do we stand with Mr. Shears' case today?
Your Honor, well, I'm in an odd position where we're kind of floating. The new case, which is the basis of the violation, has again been adjourned to the 11th of December in front of the Honorable Judge Shatler downstairs. So as you can imagine, that hamstrings us in terms of a probation violation when there's a pending felony downstairs. And it's been down there since, I think, September now. He's been in jail, Judge, for over 90 days. So at this point, Your Honor, he's done the time that would have been necessary with that the court would have probably given him as a consequence of the contempt. And I'm not the attorney downstairs, but I anticipate I'm going to be filing my appearance down there next week. So the 11th would be a go date.
Ms. McClure, anything to address from the people's side?
Just that I think I'm missing something. I don't see a probation violation. I see a violation of bond conditions.
I think she's right. It's a bond
Okay.
violation, Your Honor.
Yeah.
You're correct. I
Okay.
miss.
So
it
we
is-
would, oh, sorry. We would just ask that this pretrial be set over past December 11th for the other case to potentially get up here if it gets bound over. And if it doesn't, then we'll know after that that it isn't bound over. And as to him being in jail, his bond was reviewed after, I believe, after the violation, and the bond modification was denied. So he's not there on a violation of probation. He's there on a violation of a bond condition, but also his bond was reviewed because of that violation, and I assume because of the new case. So bond request was requested and denied by this court.
Respectfully, if I may briefly respond, it was reviewed with regard to allegations of a bond violation, Your Honor. And as a general rule, that comes with a 90-day sit down. He's been sitting in jail now for 102 days, Your Honor. Furthermore, a $100,000 bond, which is what he's presently sitting on, Your Honor, is a capital bond, is a murder bond. We're respectfully asking it to be reviewed for something more reasonable. And with regard to a date, Your Honor, may I suggest the January 8th date we just set for Mr. Fenton? So if it's bound over, should be up to you by January 8th, and if not, we can move forward.
All right, so what I'll do is set it for that January 8th date that Mr. Lyons requested. At this point, his bond is on the contempt, and he has served more than 93 days. What I would do to address that technicality is make that bond on the contempt, the new bond on the underlying charge, because I would agree that I don't think it's appropriate to continue to hold him on a contempt beyond the 93-day that would be the maximum possible sentence on the case. But I do think the bond that I set there is appropriate for the underlying charge for the reasons that the court has already expressed during its, I can't recall whether I did it on the record or in writing, but in my decision to reduce the bond that has previously been made.
Thank you, Your Honor.
So January 8th at 8:15, Mr. Shears, you can let the officer with you know that you're done with court for today.
Excuse me, is that the same bond, or is it still
Correct.
100,000? Okay.
Correct.
Thank you.
Thank you.
Have a good day.
Thank you. And Your Honor, one more thing off topic, apologies. As you know, I'm usually here early. Next time I'm out of town, I'll make sure I know what time zone I'm in.
Yeah, set that watch.
Thank you, Judge.
Okay, thank you. All right, so we can do the case matter. So this is file 24-21827-FH People versus Jeffrey Patrick case. We are here today for a pretrial conference in this matter, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Messer?
Your Honor, Ashley Messer, Assistant Attorney General for the people.
Ron Underwood for Mr. Case this morning, Your Honor. Your Honor, I don't know where Mr. Case is. This is highly unusual. I did speak to him earlier in the week, so I don't know where he is. I would ask the court to perhaps consider a show cause on this matter and set it out for 2 weeks, Your Honor, or a week if the court would so do.
All right, Ms. Messer, anything from the people's side?
Your Honor, I assume that the defendant was given notice of this date of hearing, and since we don't know where he is, I am requesting a bench warrant at this time.
All right, it would appear from my review of the file that this is a first failure to appear by Mr. Case. So I will give him 48 hours to contact the court. If we do not hear from Mr. Case within that 48 hours, the court will at that time issue a bench warrant, and I would set bond at the outstanding amount of child support. Ms. Messer, do you know that number?
You just give me one moment. I will pull that number up for you.
Your Honor, as a practical matter, that's going to be Monday or Tuesday, correct?
That is correct. So we're not open Thursday or Friday, so bench warrant would not actually issue until Monday, sometime Monday.
Your Honor, the current arrears is $42,477.55.
So $42,477 and I'm sorry, 55 cents.
Yes, Your Honor.
Okay, so that would be the bond if the bench warrant issues.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Okay,
Appreciate you.
All right, and then Mr. Kier is here. Ron, Ms. Underwood, do you need to speak to him?
Yes, thank you.
Okay. Okay, I'm sorry, Ms. Underwood. I moved him into the meeting and he has disappeared. So we'll see if he gets logged back on.
Okay.
Mr. Dagger Margosian, are you ready to proceed with Ms. Justice?
Yes, Your Honor.
This is file 24-22058-FH, People versus Jenny Mae Justice. We are here for arraignment this morning, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms.
P.V. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Miss Justice.
And Mr. Dagger Margosian, does Ms. Justice wish to have the information read?
No, Your Honor.
And how does she wish to proceed today?
Your Honor, we will be entering a plea at this time. Mr. Hartung and I have resolved this case. She will be pleading to an added count, and I think there's an amended information, or maybe on the original information submitted, she'll be pleading guilty to count 3, which is controlled substance possession with the drug enhancement, and in exchange, counts 1 and 2 would be dismissed.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
I believe so. Count 3 with the drug stuff, is that correct?
Correct.
Okay, then yes, it is.
All right, Ms. Justice, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are,
I'm sorry. I should just say that the information, the date of offense is actually October 10th and not 17th. I would just ask for that correction to be made.
October 10th. Okay. Okay, so Ms. You are Jenny May Justice, is that correct?
Yes, Your Honor.
Ms. Justice, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3, possession of cocaine less than 25 grams?
Yes, Your Honor.
Is it also your intention to plead to the second or subsequent offense notice?
Yes, Your Honor.
Do you understand that with that second or subsequent offense notice that the maximum possible penalty for the offense is up to 8 years in prison and or a $50,000 fine?
Yes.
Are you satisfied with Mr. Dagger-Margosian and the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Correct, Your Honor.
Sir, is that also your understanding, Ms. Justice?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Do you understand that, Ms. Justice?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor. Yes.
How do you wish to plead to the charge that on or about October 10th, 2024, in the city of Adrian, County of Illinois, that you did commit the offense of possession of cocaine less than 25 grams?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
You understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your
Honor. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Justice to plead guilty today?
None, Your Honor.
No, Your Honor.
Ms. Justice, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your
Honor. Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Dagger Marguzzi, do you want to cover the factual basis?
Ms. Justice, on October 10th of this year, were you in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
And on that date, did you have in your possession controlled substance, to wit, cocaine?
Yes.
And was that amount less than 25 grams?
Yes.
And you knew that substance to be cocaine?
Yes.
And you had no legal right to possess that at that time? Was it, you broke up a little bit?
I said correct, I'm sorry.
And you acknowledge that you have a prior controlled substance offense back on April 8th of 2008.
Yes.
Okay, I think I'm satisfied, Your Honor.
And Ms. Justice, as part of the investigation, the officers did locate narcotics near the garage or the shed of that home. And at this time, you would state on the record that those were not yours, but someone else at that home. Is that correct?
Yes, those were not mine.
Okay, thank you. I'm satisfied.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Dagger.
Satisfied, Your Honor. Thank you.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Justice has had full knowledge of her rights. She had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And we will set sentencing for January 17th at 8:15 a.m.
Your Honor, Ms. Justice has a sentencing on different matters in front of this court on December 6th, so like pretty soon, next week. I'm wondering if we could combine this sentencing. I mean, I know it's a quick turnaround, but all of the information in the PSI should be up to date. I think it would only be adding, just facts specific to this. I don't know how the court feels about that.
I would defer to the probation department. They're entitled to 6 weeks to do a PSI. So if that's Mr. Stevenson.
Yeah, I doubt we could get that done that early. It'll probably be a couple weeks at least before we can get that done.
That's fine.
I can notify the probation officer that if it is completed early, to contact the court and possibly set it to the sentencing earlier.
Okay. I can move it all to the 17th, and then if it works out that we can move it up, or we could try that if that.
I think that makes sense.
Okay.
Yeah.
All right, so we'll move the one for next week, December 6th to the 17th. If we get notified from the probation department that they have that done early and it can all be moved up, we will arrange for that.
And again, that was December 17th?
January 17th.
January 17th. Okay. Yeah, that's fine.
Okay. All right. So, Ms. Justice, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background. Okay, so you're all set. You can let the officer with you know that you're done with court for today. All right, Mr. Kier, I'm going to send you a request to unmute, and then I'm going to put you in a breakout session with Ms. Underwood so that you can speak to her privately.
All right.
All right. Mr. Malero, are you ready to proceed with Mr. Clement?
I am, yeah.
You're on the record in file 23-21541-FH, 24-21900-FH, and 24-21901-FH. People versus Robert Anthony Clement. We are here today in 23 case for a probation violation, in the 24-21900 case for a pretrial, and also for 2 contempts, and in the 24-21901 case for a pretrial and a contempt. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Salvatore Malero on behalf of Robert Clement.
All right, and Mr. Malero, where do we stand with Mr. Clement's cases today?
So what I would like to do, Judge, if the prosecutor has no issue with the criminal responsibility report on 24-21901 FH, I'd like to set that for trial. If the prosecutor wants to seek a second opinion, I suppose we'd have to adjourn it. And then the others, I would ask to adjourn it as a pretrial to the trial date. The court finds Mr. Clement not guilty by reason of insanity, then I think that's probably, this would be dispositive of the remaining case. That's my request.
Okay, Ms. McClure.
That's fine with me, Judge. I would be okay with that.
Okay, and so in terms of trial, how many days do you think we'll need?
Judge, if the state's not going to object to the report of the forensic department as to criminal responsibility, this would probably take 2 hours.
I don't know yet what we're gonna do on it. This was Miss Wagner's case and it just got reassigned, so we just have to look in and see what we're gonna do with it.
All right, let me set it then for a 1-day trial.
And Judge, this would be to a bench trial.
Bench trial.
Yes.
Ms. McClure, are the people agreeable to a bench trial?
Yes.
All right. So, Ms. Clark, we'll need a 1-day trial date, please.
Thursday, January 16th at 9 a.m.
I am not available that day.
Okay, Mr. Malero is not available, so we'll need a new date.
In fact, I'm not available from the 9th to the 16th of January.
Okay.
Thursday, February 20th at 9 a.m.
That's fine for me, Your Honor.
I'm available then.
Okay, so February 20th, 9 a.m., we will set a final pre-trial. For February 12th, that works.
Fine, Judge.
Court will issue a scheduling order. If for some reason the people look this is going to go in a different direction, you're welcome to contact the court to try to get it on the docket soon.
Great, thank you, Judge.
Thank you.
Okay, thank you. Mr. Clement, you have the officer with you, know that you're done with court for today. And then Mr. Malero, I have Mr. Stubbins here, David. All right, with that, your is just. Okay, so we are on the record in file 24-21943-FH, People versus Patrick Allen Stevens. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Salvatore Malero on behalf of Patrick Stevens.
And Mr. Malero, where do we stand with Mr. Stevens' case today?
Just, Your Honor, where we stand on this is we have a plea agreement in principle. Mr. Stevens has been approved for Veterans Court. He has a bed available to him with the Veterans Affairs up in Ann Arbor for December 3rd. However, he has a matter pending, I think, out in Allegan County. I contacted I called out there to the attorney. They have not called me back. And he also thought he might have something in Berer County. I called the public defender in Berer County. They have not returned my call, but it is a friend of the court matter. I called Miss Brenner, the AG in that case. She thought he was on probation and there was no violation pending. So I don't want to put a plea on and then have him have a holder somewhere else and he shipped out. So I'd like to kind of get that nailed down. I also do not want to delay his entry to veteran at the VA. So I asked to adjourn this for me to get these two other issues worked out. But I'd like to modify his bond so he can be released to go up to the VA. We'll have to figure out how to get him up there. But
okay, Ms. McClure, anything to address from the people's side?
We do have an offer that stands as it relates to his admission into Veterans Treatment Court. My only concern with giving him some sort of bond to go to the treatment center is that he has no ties to this community. And we really don't have any good way of keeping track of him or ensuring that he's going to return here to answer to these charges, given that he has potentially pending cases in for sure in Allegan County. And one of the reasons why we had allowed his admission into Veterans Treatment Court is because given that he was homeless, he could establish some sort of residency here with that program. So I guess I'm just not sure semantically how to go about it. I don't want to prevent him from going to treatment, but I also, without any ties to this community, how do we keep tabs on him and ensure he's going to return to complete the criminal matters in this case?
and Judge, I might add, he was originally approved for Veterans Court at Allegan, so I don't really know that they would stand in the way. And then they notified us that their funding or something went awry, so they withdrew that offer. I share Ms. McClure's concern. However, I think denying him an opportunity to get into treatment, and I'm sure he can zoom in if the court wants to adjourn this out to perhaps the 18th. We can track how he's doing up there. And if he, for some reason, messes it up, well, then he's got no one to blame it but himself.
Okay, I do think that at this point, Mr. Stevens has a significant incentive to comply with the treatment through the VA and continue coming to court. And so that, for me, I think satisfies the concern at this point about him continuing to appear and do what he needs to do in this case. He's being offered a significant benefit, which he would certainly lose if he does not comply with what he needs to do from here forward. So I think I'm satisfied, so I will modify his bond so that he can be released from the Lenawee County Jail to attend treatment at the Battle Creek VA Medical Center. Mr. Malero, you had indicated you didn't know how he was going to get there. We have a Veterans Justice Outreach Coordinator by the name of Jamie Wright, who works for the VA, who has indicated that he can pick Mr. Stevens up on December 2nd at AM and drive him over to the VA Medical Center in Battle Creek. So I would modify the bond conditions to allow Mr. Stevens to be released to Jamie Wright on December 2nd AM to be driven to the VA Medical Center.
Is that something I have to continue to arrange, or is that just, it's all set?
I don't think so. My understanding is that Mr. Wright is planning to do that.
Okay. All right, great.
He will be here without any further coordination.
Excellent. Thank you, Judge.
And so we'll set I think we also, through the Veterans Court, made an inquiry, and it is possible for him to attend hearings by Zoom from the VA Treatment Center. So set another pretrial matter for December 18th at 8:15 a.m.
Your Honor.
Mr. What did you have a question, Mr. Stevens?
Yeah, I was arraigned back in September on a probation violation out of Berer County. And it is through front of the court. They set a very high bond, and then I'm scheduled for sentencing in Allegan on January 27th. I just received a order by mail from them. I'm not sure how that's gonna be getting out to go to treatment. That's my concern.
My understanding from our jail is that there aren't any holders on Mr. Stevens at this time that would prevent them from releasing him to Mr. Wright.
Okay.
Judge, I got called in the Allegan County and to Berer County. I'm just waiting to call back. I will try to track them down.
And I saw that this was coming up yesterday. I had Ms. Clark contact the jail to see if there were any holders, and they said there were none. So
great.
Okay.
I think it's going to work out, but
let's hope.
Yeah. My concern is that when they run a lien, when they release me, that's when those holds are going to show up. I talked to the CO here, and they had said that they don't run a lien until they're released. But maybe that's different with you asking.
Okay. I will try to sort through that and see if we can find out in advance, because again, it's Mr. Wright comes from out of the area, and Battle Creek is even further out of his area. So I'd like to avoid having him come down if that's not going to work out. So we'll do everything we can to make sure it's going to work before the time comes.
Okay, thank you. Thank you, Your Honor.
Okay. All right, you are all set then, Mr. Stevens. You can let the officer with you know that you're done.
Thank you.
Thank you. Let's see. Oh, okay. Ms.
Judge, I need to do the step in order, I take it.
Oh, if you would, I would appreciate it.
I would gladly do it for you, Judge.
Okay, so Ms. Unwood, are you ready to proceed with Mr. Kier?
Your Honor, if I could just have, I spoke to Ms. Holly, so I just need a brief breakout with Mr. Kier.
1 second. Okay, Mr. Mr. Kier, is there something asking you to join a breakout session?
Yeah, I already hit join.
And nothing's going on?
No.
Let me try something else. Okay, let's see, Mr. Glazier, have you had any communication with Mr. Beyer? I don't have him here today or logged in.
Yes, I have, Your Honor. I talked to him and he's waiting for me to call him back. He didn't have notice of this, he says, Your Honor, and he has been offered a misdemeanor with no upfront jail, which we're going to do. I was going to ask if we could maybe adjourn it and have him Zoom from our office next week to enter that plea. He's over in Petersburg, but he's just waiting my call. I can get him on the phone if Your Honor wants.
Let's do it on the 11th rather than next week.
All right, December 11th
Yeah,
at 8:15.
correct. And will you do a stipulation in order?
Yeah, I'll prepare the stip and I'll give him a call right now and advise him that he's got to be in our office to Zoom on that date.
Okay.
All right. Thank you, Your Honor. That's all I have with you this morning.
Okay, thank you. And Mr. Murphy, have you heard from Mr. Madison?
Your Honor, not this morning. I think we can go on the record with Mr. Madison if you wanted to do that. I think he already has an outstanding warrant on file.
So this is file 24-21997-FH and 24-21996-FH, People versus Brandon Lorenz Joe Madison. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonet for the people. Matthew Murphy, appearing on behalf of Mr. Madison.
All right, and the record should reflect this matter was set for hearing this morning at 8:15 a.m. It is now 11:12 a.m. Mr. Madison is not present either by being here in person or by logging into the Zoom session. I do note that the file already contains a warrant for his arrest related to failing to drug test. But he's not present here today. Mr. Murphy, anything you would like to address today?
Yes, Your Honor. I would like to place on the record briefly the communications I've had with Mr. Madison. He did have a pretrial down in district court about 2 weeks ago that he failed to appear for. He had contacted me, my office. He called my office later that afternoon. And then he started texting my personal phone number. The text messages were back and forth for that week. He was saying he was going to come in and turn himself in on that outstanding warrant. Actually, the Judge Shaler hadn't put out a warrant for him yet. We weren't aware of this, the warrant for him on the bond conditions on this file or before, Your Honor. He didn't turn himself in. There was back and forth. We arranged multiple dates and times. He didn't appear for those dates and times. He was expressing disbelief in the fact that he has a warrant for the failure to drug test. He communicated with Mr. Coase, I believe, before that, and then he communicated with Mr. Coase, I believe maybe sometime last week. I believe Mr. Coase had confirmed with him, yes, we have drug testing conditions. Mr. Madison was again concerned because he didn't believe he had testing conditions on the probation he was currently on. Again, Mr. Coase expressed again, he has those conditions on his bond for the ones pending. Mr. Madison had texted, then the messages were no longer going through. I called his number repeatedly from the office number, telling him, leaving messages on that phone number that I had, to call my office, repeatedly leave messages at my office if there wasn't any answer, that he needed to address these outstanding warrants. And again, that's the last I've spoken with him. Again, the communication, it's sporadic. I don't understand why. I mean, these are very serious things. I do anticipate Mr. Madison will probably come in, probably talk to my office to come in maybe in a week or two or something like that. But I do apologize to the court for his absence and for the issue with the bond.
Mr. Bayonet, anything that the people would like to address?
Your Honor, given the fact that there are already multiple warrants out for Mr. Madison, I would request a bench warrant in these files as well. I don't believe this is Mr. Madison's first failure to appear. Maybe not on this case, but I have had Mr. Madison on other cases in which he has failed to appear. So I think a bench warrant is more than appropriate at this time, Your Honor.
Judge?
Yes.
He's currently on probation with us, and he has not been reporting this month. So we have a show cause set up for him, I believe, early next month.
All right, so appreciate it and am aware that he has failed to appear in other cases. The statute indicates that he's entitled to the 48-hour grace period in each case, as I understand it. Does not fail to appear in this case. So he would be entitled to the 48-hour grace period, or in these cases, would be entitled to the 48-hour grace period. So I will allow him that. If we do not hear from Mr. Madison in 48 hours, or as a practical matter by Monday, December 2nd, which is the next day the court's going to be open, the court will issue a bench warrant at that time, and I would set bond on bench warrants at $5,000 cash or surety in each file.
John, I'm sorry, I just wanted to clarify, that's not including the already present bench warrant for his non-performance on the bond conditions?
Correct, so these are new warrants.
Thank you, Your Honor.
For the failure to appear. Okay. All right, we are on the record in file 20-20077, 21-20551-FH, and 21-20552-FH. People versus Timothy Allen Kier. We're here today for hearing on
There's a couple more if you want them.
Probation violations. In these cases, we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Kier this morning, Your Honor.
All right, and how does Mr. Kier want to proceed today?
Your Honor, after speaking with Ms. Holly and Mr. Kier, Ms. Holly is going to dismiss the non-technical domestic violation, Your Honor. That matter was dismissed in district court as well. And Mr. Kier will plead to the technical violations, Your Honor.
Okay, is that accurate, Ms. Holly?
Yes.
Okay. Mr. Kier, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Timothy Allen Kier?
Yes.
Mr. Kier, do you understand that you have a right to contest the violation of probation charges and have a trial on them?
Yes.
You can put your hand down if you want. Do you understand that throughout the trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes.
You do not have to testify at your trial, and no one can hold that against you in any way. Do you understand that as well?
Yes.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that also?
Yes.
How do you want to plead to the charges that you violated your probation by failing to report as instructed and failing to pay court-ordered costs and supervision fees?
I did report. I didn't miss no reports.
Right, so Mr.
Your Honor, or Ms. Holly, can Mr. Kier plead to the fines and costs violation?
He's been reporting now, so yeah, that's fine.
Okay. So then it's just the failing to pay costs and supervision fees. How do you want to plead to that, Mr. Kier?
Guilty. I have work, but I can't get a legitimate job because I have epilepsy. I've been fighting for disability for over a year.
Okay, so I'm not here to make you plead guilty. If you're going to plead guilty, you would have to admit to the facts that support your plea. And again, it's your choice on whether you want to do that or not. If you don't want to do that, I can schedule it for a hearing and we'll have a trial and I'll hear you out.
But I am guilty for non-payment of fines and costs and stuff. I was just letting you know why I can't, why I haven't been able to.
Okay, so what you're telling me though is that you don't have the ability to pay.
Yeah.
All right.
I don't have the funds.
All right. So what I'm going to do is set it for a hearing. The court has to make findings and a determination as to whether there's an ability to pay. So we'll set it.
Hold on. So it's being set for another hearing?
Yes. So you have stated that you don't have the ability to pay the fines and costs.
Yeah.
I have to have a hearing in order to make that determination where you're allowed to present evidence on that issue, and then I'll make a decision. But I can't do that today. So I have to set it for another hearing, which is what I'll do.
All right.
So, Ms. Clark, I need a 1 hour hearing date for Mr. Kier.
Friday, December 20th at 11 a.m.
Ms. Underwood, does that work
That's
for
fine,
you?
Your Honor.
Ms. Holly, does that work for you?
Yeah, that's fine.
Was that 9 a.m.?
11.
Oh,
11.
I'm sorry, 11.
All right, so Mr. Kier, December 20th at 11 a.m. and that's an evidentiary hearing, so you'll need to be here in person in the courtroom for that hearing.
Okay, well, I do have one question.
What is your question?
I was supposed to be released from probation on October 28th.
Well, you have a pending allegation of a probation violation, so that kind of stays the release of probation. Yeah, so I've just explained to you what the law is. I'm not going to argue with you about it. So December 20th, December 20th, 11 a.m.
Mr. Kier, call my office and we'll talk about this, okay?
All right.
Thank you.
All right, so Mr. Kier, you are all set for today. You need to be here on December 20th at 11 a.m.
All right.
Your Honor, did we have an Ashley Beam scheduled?
Thank you, Judge.
I do, but she is not here, so this is file 23-21399-FH People versus Ashley Nicole Beam. We are here today for a hearing on a summons order to show cause for probation violation. We are proceeding today by video conference. Courtroom is also open to public. This matter was scheduled for 8:15 a.m. this morning. Ms. Beam was ordered to appear. It is now 11:24 a.m. Ms. Beam has not appeared at any point this morning, either by coming to the courthouse in person or by logging into the Zoom session. I am therefore going to issue a bench warrant for her arrest for a failure to appear. I would note that she does have other failure to appears in this file, and so she's not entitled to the 48-hour grace period. So I'm going to issue a bench warrant and set bond on that bench warrant in the amount of $25,000 cash or surety.
Thank you, Your Honor. I believe that concludes my docket with you this morning.
Okay, thank you, Ms. Underwood.
Happy Thanksgiving.
Thank you, you too. All right, Mr. Murphy, ready to proceed with Flores case?
Yes, Your Honor.
Judge, is that the last thing you had on your morning docket?
Yes, that's all I had.
Okay, I must have missed one. Jeffrey Beyer.
Oh, I'm sorry. We adjourned him to December 11th.
Okay, sorry about that. I don't know how I missed that. So, okay, I'm gonna go ahead and log out and I'll see you this afternoon for our PPO.
Okay, thank you.
Your Honor, just this motion was filed on both Mr. and Mrs. Flores' cases. I represent Mr. Flores. Ms. Hennigan represents Mrs. Flores. I don't see Ms. Hennigan here. I don't know if she was, oh, she's there on Zoom. I didn't know, I was intending to argue first, and then if Ms. Hennigan wanted to, supplement after that, if she's okay with that, that was my intention. Is that okay, Ms. Hennigan, for me to argue first?
Absolutely fine with me.
All right, so this, we are on the record in two files, file 24-21845-FH and 24-21886-FH. People versus Raymond Flores in the 845 matter and People versus Emily Flores in the 886 matter. We're here today for a hearing on a motion to quash the information and dismiss. We are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto for the people.
Alex Bayonetto for the people.
And Mr. Murphy.
Matthew Murphy, appearing back for Raymond Flores.
And Ms. Hennigan.
Tamiris Hennigan on behalf of Emily Flores.
All right, Mr. Murphy, if you'd like to proceed with oral argument, you can do that now.
Yes, Your Honor. There wasn't much I was going to add. Your Honor has the briefing that we filed on this matter. I just wanted to express again, reiterate that as the courts have expressed in their opinions in the cases that I cited in our brief, the burden is on the people in this matter to show that the police acted in accordance with procedures to avoid the, I guess you would say arbitrary impoundment of vehicles. And that was clear from the case that we had cited. Now, in this matter, we provided the court with body cam footage. I do apologize to the court for the length of that body cam footage. I had contemplated and was going to submit just the brief portion, the first 5 minutes or so. But ultimately, we decided to submit the entirety of the body cam footage to the court. As you can see in the body cam footage, it's pretty clear. We believe in the body cam footage that the officer in this matter, they weren't acting in accordance with any cited procedures. The officer, as Your Honor could see from the body cam footage, he was allowing Mr. and Mrs. Flores to try to take the vehicle away, allowing to get a person to come. He actually had expressed that make sure the person that comes is a valid licensed driver. And that, as Your Honor, as we point out in the brief, as you can see in the body cam, that's what ultimately started the exchange that we said that it led to the arbitrary impoundment of the vehicle. The officer got upset with the reaction that Mr. Flores was, again, Mr. Flores was intoxicated. That was understandable. or that was admitted to. So it should have been understandable that he was acting, again, not very rational. Mr. Flores had insulted the officer. That led the officer to then say, okay, well, now here's what's happening. We're going to impound the vehicle. Again, the fact that people may later on try to come up with some explanation for why the officer could do what he did, that's not the lodestar. That's not the guiding post, Your Honor. The guiding post is what the officer did at that time, what his intentions were at the time. That's why, again, the case that we cited, they were showing how volatile this situation is. As they said, a person has a right to defend themselves against illegal police action, and that's about the action of the police at the time that it occurs, not later on, not at a hearing a month or 2 months or 6 months or a year later. It's a reaction to what's occurring at the time. And that's why the body cam footage is important in this matter, because the body cam footage showed the court what the officer was doing at the time and all the actions that occurred after that. And again, we also want to point out that the policy that was cited by the prosecutor in this matter, that's not the end of everything, Your Honor. There is, obviously, there's a case, there's a statute involving this, MCL 257.25D. That is the state statute that involves towing of a vehicle. Now, the policy that the prosecutor had cited here, it ultimately says that the police, I mean, it's the Adrian City Police Department's policy, and I have concern about the section because it ultimately says that it's at the discretion of the police department. And I don't think that's important with the statute, Your Honor. That's exactly against what they're trying to prevent here. That the statute says that you can't have it just where they decide to use their discretion. They have to follow per the procedures. And again, we cite here, we cited the case that show that, again, the reaction, as we're arguing, Mr. and Mrs. Flores' actions were trying to defend themselves against the illegal towing of the vehicle. And I go on to further to Mr. Flores' case. After his interaction, as you can see from the body cam footage, the police tried to say, well, now you have to leave. Now you're being disorderly. And again, as we tried to express, he was doing exactly what the police were trying to tell him to do, which is he went off on the sidewalk. And then they say, well, now you're being disorderly by being intoxicated, which they knew he was intoxicated, and being intoxicated, being on the sidewalk and acting the way you're acting. Again, he was objecting to the police. I phrased it in my brief as verbal resistance. He wasn't punching, he wasn't fighting, he wasn't physically at that point, but he was saying things to stop the police from doing what they were doing. Also, I want to point out that once that moved onto the sidewalk, again, freedom of speech, as he expressed in the video, he believed he was protected by freedom of speech to express his disapproval of what the police were doing, and again, trying to stop them from illegally towing the vehicle. Now, again, the situation isn't ideal. Mr. and Mrs. Flores were intoxicated. That's again why we fall back on what the case have cited, where this is involving the person's reaction to the police at the time. And again, with them being intoxicated and the police officers not being intoxicated, there should have been some sort of de-escalation on the part of the officer, as opposed to oh, I don't like what you're saying, let's tow the vehicle. That's why these things occur. That's why the police are trained in the matter, and they're supposed to follow the procedures. If they follow the proper procedure in this matter, again, according to the statute, I'll read this. Does the court want to provide a copy of it, or does the court need the statute that I'm referring to here?
I can look it up.
According to the statute, Your Honor, it says that if you go to 257, again, 252D2, it says, unless the vehicle is ordered to be towed under subsection 1A, D, E, or K of this statute. So let's refer to section 1A. 1A is that if the vehicle is in such a condition that the continued operation of the vehicle upon the highway would not constitute immediate hazard. That's not the case here. Let's go to section D. If there's a reasonable belief the vehicle is the vehicle or any part of the vehicle is stolen. I don't believe that was asserted here. Go down to section E. Section E is if the vehicle must be seized to preserve evidence. That wasn't asserted here. And section K says if the vehicle has been involved in a traffic accident. That's not the situation here. So again, the section says that unless it was one of those four, that when the owner of the vehicle becomes present, the keys must be turned over to the owner. That the vehicle must be, the towing must stop. That if it's actually on the tow truck, it must be taken off the truck, and the person must be allowed to pay it out. That's what the section says. So from my understanding, the prosecution is trying to assert that it was being towed per the Adrian City Police policy. Again, from my understanding, that policy wouldn't dictate that they wouldn't have to follow this statute that says that once the owner, granted that Ms. Flores couldn't drive, but she had a person come, and you could see on the body cam, they came within a few minutes. And that was expressed to the officers at the time, that they was gonna be there immediately in a few minutes, and they were there, which actually the people had cited as causing the bigger issue. 5 people arrived to take the vehicle away. According to the statute, what we're saying is that at that point, anything further, before that, okay, but at that point, it should have been turned over to Ms. Flores to then be turned over to them to drive away from that property, Your Honor. So again, I went longer than I expected to. I do apologize for that, but we do believe that if you get looking at the case law that we cited in our brief, looking at the body cam footage, and again, remembering the burden's on the people, that the police have to follow proper procedures here to the T as much as possible to avoid arbitrary and discriminatory behavior on their part. And again, they should not be allowed to just decide it's in our discretion to tow a vehicle now. So with that, Your Honor, we would ask the court to grant the motion to quash. We would ask the court to dismiss the case based upon that. We would also ask the court in the alternative that if there was further necessity for it, in lieu of not completely dismissing our motion, to perhaps grant a remand down in district court for a examination. I guess if that was another option the court considered doing. Of course, I believe based upon the body cam footage provided that there will be no further evidence presented at the examination that would further help the situation or further explain or have any other further facts. So I would ask the court again to grant the motion to dismiss. Thank you, Your Honor.
Did the defense waive the prelim?
Yes, we did, Your Honor. We waived the prelim, but things didn't go the way we were expecting.
Ms. Hennigan.
Thank you, Your Honor. Just very briefly, I would concur with everything that co-counsel has stated here this morning, and I would just add that with specific regard to my client, Emily Flores. Emily Flores is the actual owner of the vehicle, and she was not engaging in any inappropriate activity with the police. She was trying to make positive decisions that night. She had a sober person driving the vehicle, even though she and her husband had been drinking. The vehicle was pulled over and the driver cooperated in going into custody. And she asked, Ms. Flores asked the officers if someone could come and get the vehicle. She immediately got on the phone with her children, adult that were licensed drivers, and asked them to come to where they were to pick up the vehicle. And the children did just that. They got en route to come there. It was during that time that Mr. Flores had altercation with the officer, verbal altercations with the officer that has been described to you here today. But Ms. Flores was not involved in that. And in fact, while she was loud and boisterous because of being under the influence of alcohol, her comments were directed at her husband and telling him to shut up and cooperate with the officers. So at no time was she indicating that the officers were doing anything wrong up until the point that her family did arrive to pick up the vehicle. And Mr. Flores at that time had already was being taken over to the police car due to his altercations with the officers. At that time is the only time that Ms. Flores got in the way of the officers, and her only concern was that she did not want her car to be towed. She was indicating to the officers that they could not tow her car because she had someone there to pick it up and that they had told her someone could come and pick it up. She stood in front of, well, I should say on the side of the vehicle, and that was in an effort to prevent the officers from taking her vehicle, not to try to be resistant or obstructing, but because they were illegally towing or attempting to tow the vehicle, even though she had licensed drivers present, and it was actually the licensed drivers who helped to calm her down and move her out of the way at that time, even though everyone there, all of the people involved felt that the officers could not legally tow the vehicle, but they did try to help Ms. Flores get out of the way. So we would absolutely agree that this was not an appropriate tow per the statute, and that none of the situations that would require a mandatory towing occurred. And I would just stand on the statement that my client owned the vehicle and as owner of the vehicle was not doing anything inappropriate that would cause the officers to tow her vehicle. Thank you.
give me just 1 second.
Yeah, sure. Need a second to get set up anyway.
I'm sorry, Mr. Murphy, what was that statutory section?
The statute, MCL 257.252D.
All right, go ahead, Mr. Bennett.
Thank you, Your Honor. There's a lot to unpack based on the arguments that have been made this morning. I will start first with the argument Mr. Murphy made regarding MCL 257.252D. Your Honor, I don't think it is in dispute the fact that the driver of the vehicle, Mr. Sargent, when ordered to by police, pulled into a private driveway, not owned, that property not being owned by either Mr. or Mrs. Flores. That vehicle pulled into the driveway behind vehicles that were already parked in the driveway. That can be seen on the body cam footage. Again, I don't believe that that fact is in dispute today. Given that scenario, that situation, Your Honor, I think the court first has to determine whether or not a vehicle could be towed. 257.252D1G provides that authority to the police. Specifically, it says a police or governmental agency designated by the police agency may provide for the immediate removal of a vehicle from public or private property to a place of safekeeping at the expense of the last titled owner of the vehicle in any of the following circumstances. Specifically, subsection G states if the vehicle is hampering the use of private property by the owner or person in charge of that property or is parked in a manner that impedes the movement of another vehicle. Given the fact that Mr. Sargent pulled into a private driveway behind another vehicle, this situation falls under just that. So the police had the at least statutory authority to tow the vehicle in that instance. Now, Mr. Murphy also cited subsection 2, which states that unless the vehicle is ordered to be towed by a police agency or governmental agency, if the owner or other person legally entitled to possess a vehicle to be towed arise arrives at that location where the vehicle is located before the actual towing. And then Mr. Murphy went into what the police have to do in that situation. However, Your Honor, the first sentence of that subsection states, unless the vehicle is ordered to be towed by a police or governmental agency. The police in this matter, by that point, by the time anybody else had showed up, had ordered the vehicle to be towed. That's why the defendants were outside the vehicle, and the situation had begun to escalate. So they clearly have statutory authority to tow the vehicle. Now, as it relates to the defendant's actions after they found out it was going to be towed, or any factual actions is a question more appropriately determined by a jury. The legal argument is that the police did not adhere to any type of written procedure. However, Your Honor, I did provide as Exhibit A to my response, the Adrian Police Department procedure, impound discretion at arrest, which states that the owner, or if the owner of a driver or driver of a vehicle is arrested and is not available to drive the vehicle away, the affected vehicle shall be impounded unless the owner or driver can immediately turn the keys over to a licensed driver. Now, Your Honor, again, I don't think the fact that that Officer Allen with the Adrian Police Department originally stated that they could get a driver there quickly, and then later rescinded that is at issue today. Right? We would stipulate to that. The defense has argued that throughout the pendency of this case. However, Your Honor, the case that the defense relies on, People versus Toohey, specifically states that courts need not second guess a police officer's exercise of professional judgment regarding impoundment of an automobile when the judgment is exercised in accordance with otherwise reasonable police department regulations. Your Honor, the court has further clarified that and stated that courts should not, absent bad faith, render unconstitutional the decision to impound. There's no bad faith that can be shown in this case. So this court should not find that the impoundment of the vehicle was unconstitutional. We have officers who have a situation that is calm to start with, allowing a licensed driver to come get the vehicle. However, once Mr. Flores becomes agitated and begins displaying anger towards the officers at the fact that they would not tell him the information he wanted to know, now we have a situation where officers have to, I agree with Mr. Murphy, they have to try and de-escalate things. That's why they told the Floreses, you know what, if this is going to escalate, go home, we're going to impound the vehicle. They allowed Mr. Flores and Miss Flores to get out of the vehicle. They told them several times to go home. That's shown repeatedly in the body camera footage. So, Your Honor, given the fact that the officer's policy states that they have to impound the vehicle, shows that they are operating within written procedures. There's no argument that these are unreasonable, that officers were not using their proper discretion when deciding to impound the vehicle. So I think based on the cases that the defense cites, this impoundment was constitutional. Just finally, Your Honor, I won't belabor these points anymore. Mr. Murphy also cited free speech arguments in his argument before the court. There's not been any law that's been cited up to this point that would provide the speech that Mr. Flores was using to be protected. I would ask that if the court does want to explore that First Amendment potential issue, that be briefed before the court making a decision on that. But anything as it relates to whether or not Mr. Flores was disorderly is a question of fact for the jury. So just in summation, Your Honor, the statute cited by the defense clearly provides the Adrian Police Department the ability and the legal authority to tow the vehicle. There their department policy and procedure is that unless there's somebody there immediately, they have to tow the vehicle. So that's what they were acting in accordance with. So Your Honor, I would ask that the court deny the defense's motion in its entirety. Thank you.
So Mr. Bayanetto, can I ask you, when the initial statement was made that they would wait to allow someone else to come and take the car away, would that be in compliance or not in compliance with the city's policy about impounding vehicles?
The police officers do have discretion to allow that. It is located towards the end of the policy that I provided. So they do have discretion to not tow a vehicle. But again, as the
well, where is that? Because the paragraph I see says that deviation from this policy requires approval of the shift supervisor.
Yes, Your Honor, and I can't say that they did contact the shift supervisor. I believe that was Sergeant Graff. I know he did show up on scene. I don't know at what point or if they contacted him. So I can't say for sure today whether or not they did or not contact him. But before that happened.
At what point, I don't recall, at what point did Officer Graff show up?
So if the court watched the whole body cam,
so I guess I should say, I'm sorry to interrupt, but I should say that I watched up until the point where the other people that came started walking away, and it looked like, to me at least, the relevant portion of the interactions were completed.
I would agree with that. I don't know exactly when Sergeant Graff showed up. I do know it was, I believe they ended up putting Mr. Flores in Sergeant Graff's car. So I think it was right after the situation with Mr. Flores happened and as they were trying to get him in the vehicle.
I can go back and look again. I'm not trying to.
From my recollection, I believe that's when.
I'm not trying to hold anybody to anything. I just thought if someone absolutely knew. So, okay, Mr. Murphy, you care for any rebuttal?
Yes, if I could. I'll try to be brief, but I always lie when I say that. Hold on. I'm sorry, my computer locked me out. Your Honor, if I could refer back to my brief. I'm just going to quote what I put in the brief, because it says the impoundment of a motor vehicle is a seizure that must be scrutinized under the Fourth Amendment of the United States Constitution, Article 1, Section 11 of the Michigan Constitution of 1963. And I cite People versus Tui. And I go into, again, in order for a seizure of a vehicle to pass constitutional scrutiny, there must be an established, and this is where I quoted Tui, an established set of procedures which the police must follow. I'm putting emphasis myself right on the must, but it wasn't in my text. Must follow in making the determination whether to impound the vehicle. The critical factor in determining whether too much discretion has been granted to the police officer regarding impoundment of an arrested person's automobile is the ability for arbitrary searches and seizures. Your Honor, that's why I cited, I have a concern with the statute or the Adrian City Police Department's policy. Again, they can't create policies that go against the Constitution. They can't create policies that go against
how does this go against, how does their policy go against the Constitution?
I'm referring to the discretion, Your Honor.
What discretion do they have?
Well, that's because
the policy. Where is the discretion?
In the Adrian City Police Department's policy, where it says that they can contact a shift supervisor. Deviation from this portion of the policy requires approval of the shift, and as Your Honor was discussing with the people, and I'm saying that section right there. That just opens the door for discretion. That again, in my opinion, will be against the idea that there should not be allowable discretion in the matter. They should be following these procedures.
But TUI allows for some discretion, right?
Well,
it doesn't say the policy can have no discretion. Yeah, no discretion. It's clear. The law clearly gives the officers an ability to have some discretion in these matters, doesn't it?
Yes, Your Honor. But yes, I'm not saying that they can't have any. What I'm saying is this situation shows that there's too much discretion allowed. If this is a policy that was being followed, it allows for too much discretion in this matter because of what happened. That's what I was trying to say, Your Honor, that if the case was a situation they were following this policy, I think that policy allows for too much discretion because of exactly what happened here. But I would say actually they weren't following the policy because they didn't get prior approval by any shift supervisor. But I would say that's also the issue that we would have here, is it butts up against the idea of maybe too much discretion if all they have to do is get a supervisor to, after the fact, say, yeah, that was okay. And the reason for, again, why I'm bringing this up, I don't mean to hammer it too much, but I think the concern ultimately is, again, looping back to when people observe a police officer they believe is acting illegally at that time and place, the person can act, again, if they have an honest belief in that, they can act upon that and defend themselves. If the case is cited, they can defend themselves from that illegal police action right then and there. So the problem you have with a policy that may give too much discretion is that, again, what I believe happened in the situation. Now, if the police believe they're following their policy, that they could later get approval for the deviation of not immediately then and there towing the vehicle, then I would say that would be an example of why too much discretion could be a problem. But also, Your Honor, I wanted to point out that the statute, again, as we all know, statutory interpretation and reading creation of the legislature, the statute, the language says, unless the vehicle is ordered to be towed by a police agency or a governmental agency designated by a police agency under subsection 1A, D, E, and K. There's no break, there's no comma, semicolon, anything. That statement is all encompassed. That means that unless it's told by the police agency per those sections, it doesn't say by a police agency or then separated. It's by, because those police agency or government agencies will be the ones towing under those sections. So I don't believe that it's appropriate. Again, the burden's also on the people here. So if there is any type of I guess ambiguity in the statute, then I would say that the rule of lenity and the fact that they have the burden here would fall back on the defense. But I don't think there's any ambiguity in that statute. There's no break, there's no comma, there's no separation of the ideas of that sentence right there. Unless the vehicle is ordered to be towed by a police agency or a governmental agency designated by a police agency under subsection 1A. Would you read that to say that, well, is the governmental agency designated by the section under 1A? No, you wouldn't read it to say that. So again, I'm arguing that this section says that as the people argued, they were towing under section G. If they were towing under section G, then when the owner had a legal licensed driver come, then it should have been turned over per that statute. Thank you, Your Honor.
Ms. Hennigan, do you care for any rebuttal?
Very quickly, Your Honor. Mr. Bannetto cited subsection G that the vehicle was hampering the use of private property. I just wanted to point out that this was late at night. The property owners were not even involved in this incident, and neither were they trying to move their vehicles at that time. That Ms. Flores did have someone come immediately. And so the car being there for a couple more minutes while those people arrived would not hamper the use of private property. Also, that this vehicle is owned by Ms. Torres. And so the prosecution has not indicated anything that Ms. Torres did that was a cause for the vehicle to be towed. So again, her behavior with regard to trying to stop them from illegally towing her vehicle was appropriate for her to ask for them to stop. Not saying that the manner in which her behavior was conducted was completely appropriate, but her request for the vehicle not to be illegally towed was appropriate. She should not pay the consequences for anyone else's behavior if, in fact, the officers felt that there was an issue with Mr. Flores' behavior. I also, though, concur with Mr. Flores' attorney that he also had a right to ask that the vehicle not be towed, and that was why he was emotional and upset. But whatever the case may be, Ms. Flores was not interfering with the officers doing their job. Thank you.
All right, so oral argument today has raised the issue of how MCL 257.25D interacts with the case law, and that was not briefed, so I wasn't particularly prepared to address those issues. I don't think I'm comfortable doing that now off the cuff. I would rather make sure that I give it a thorough reading rather than reading while I'm trying to listen and and make sense of it all at the same time. So I'm going to take the motion under advisement and issue a written opinion, which we will be to both sides as quickly as we can once that's finished.
Do you want to have further briefing on the issue, or are you okay with what's been said?
I don't think I need any further briefing on the matter right now. I think I just need to sit with it and read through it in light of the arguments that have been made. If I determine otherwise, I'll issue an order asking for.
Thank you, Your Honor.
Right. Thank you.
I was trying to figure out when did you guys get the new chairs in here and everything? I apologize. I don't really go with the lighter wood though. I'm sorry.
They're far more comfortable. So
yeah, well, there's that. I was like gonna fall asleep on them. Thank you, Your Honor. You have a good Thanksgiving.
Thank you too.